Veteran on the Move, episode number 18. Welcome to Veteran on the Move, your pathfinder to freedom. If you're a transitioning veteran, an entrepreneur wannabe, or someone who's still stuck in that job trying to escape, this podcast is dedicated to your success. So welcome aboard, sit back, and enjoy the ride. Dr. Marty High is a practicing attorney and engineer. He earned his Bachelor of Science, Master of Science, and PhD degrees in Chemical Engineering at Penn State and his Juris Doctor at the University of Tulsa. He is a licensed professional engineer in the Commonwealth of Pennsylvania and has practiced as a registered patent agent and a patent attorney since 2001. He has been involved in complex litigation and intellectual property matters in both state and federal court, primarily in class actions involving oil and gas royalty disputes. He has taught chemical engineering at Oklahoma State University since 1991 and has over 35 years of engineering experience. He has published technical papers in a variety of engineering areas, including thermodynamics, polymer science, corrosion, and catalysis. His legal practice primarily involves helping individuals, startups, and small businesses protect their intellectual property rights while starting and expanding their businesses. Dr. Marty High, it's great to talk to you again.
Nice to talk to you too.
I wanted to talk patents, copyrights, and trademarks. Let's start with the basics. First of all, what's the difference between the three?
Okay. Well, the three are related but have different scopes of protection. Let's start with copyright. I think that's the easiest one.
Okay.
Copyright protects the expression in a work. In other words, if you think about, if you think about a musical, if you think about Rent, the musical, copyright protects the expression in everything that's involved in that musical, the music, the lyrics, even the choreography. Anything that you can put in a fixed, tangible form, you can protect. But in contrast, and this is where the contrast between copyright and patents are, patents protect functionality and not expression, and copyrights protect expression and not functionality. So, for instance, if I would write a song for the musical Rent, which is absurd in its face. I can't read or write a single note of music, but
I'm with you.
that nodded aside, if I would put expression into that writing, it would protect that expression. But if I would write a musical about how a brake shoe is put together and how it functions, the copyright would only protect the expression in that song and not how to build or operate a brake shoe. If I want to protect the functionality of something, I need to write a patent and find a patent application. So the main difference between patent and copyright, and it's good to talk about them hand in hand because of this dichotomy. Copyrights protect expression, patents protect functionality, except for there's a type of patent called a design patent that protects the ornamental look. So if you think about the Nike swoosh or a Corvette hood, there's no functionality necessarily with the Nike swoosh, but there's an ornamental look to it, and you can protect that with what's called a design patent. Most patents that people think about are called utility patents. So design patents kind of go halfway between regular utility patents, and copyrights by protecting the ornamental look. The other way to contrast patents and copyrights is the terms for copyrights are essentially infinite. They're the life of the author plus another 70 years. So if I would write that score about a brake shoe for a musical, I would own the expression, not the functionality, but I would own the expression in that brake shoe for my life plus an additional 70 years. So the day I die plus 70 years is when I would own that copyright. A patent, on the other hand, a regular utility patent, lasts from 20 years from date of filing, and a design patent the term of a design patent is 14 years from date of issue. So the terms are different too. Again, protecting that either that functionality or that ornamental look or the expression. 70 years plus life of the life of the author plus 70 years for the expression, and either 20 or 14 years for the functionality or the ornamental look. So that's the basic differences between copyright and patent. And then, did you say trademarks or trade secrets or both?
Well, let's cover both if you can.
Sure. Trademarks, we'll take up trade secrets last. Trademarks are different still. They protect the business behind the trademark. And if you think about really well-known trademarks like Coca-Cola, that trademark protects the business behind the product. In other words, if I would take Coke cans and empty them and then brew my own Coke product or Coca-Cola product in my garage, and then fill the cans and seal the cans and then sell them in Coca-Cola cans, I would be what's called palming off. I would be using the goodwill that's been built up by Coca-Cola for over a century now to sell my product. And I'm infringing on the goodwill that's garnered by the business behind the product. The product's only there at the present, but the company has been around for 100 years plus and has garnered a lot of goodwill. So the trademark protects that business to keep me from doing things like palming off, or by taking their mark and putting it on my product and selling it as theirs, or taking their product and selling it as Marty's Cola. If I would take a can and put Marty's Cola in and put Coca-Cola in Marty's in Marty Cola cans, that will be what's called reverse palming off. I'm taking their product and putting my mark on it. So trademark is about unfair business practices. It's about protecting the business behind the mark. Trademarks are different from copyrights and patents in that there's no constitutional basis or direct constitutional basis for trademarks. In fact, there were a number of times in history that the federal government tried to enact trademark legislation, and it was ruled unconstitutional. The trademark patents and copyrights are hardwired right into the Constitution. In Article 1, Section 8, Clause 8, it's the patent and copyright clause. Trademarks, federal trademarks, operate under the Commerce Clause in the Constitution, and have only been around since about the 1930s. So they're more of a recent invention, but of course, again, they deal with unfair trade practices. And then lastly, trade secrets. It's not too far-fetched to say that trade secrets are anything that you can keep your mouth shut about. If there's a process or a secret ingredient, see Coca-Cola, or other types of things that you can keep secret, that you can keep your mouth shut about, then those can be trade secreted. And the way you protect that trade secret is by contract with employees and vendors that they agree to keep the information confidential, by other means to keep things secret, keep the building locked. I mean, as simple as keeping the building locked, as simple as making sure that you don't show visitors the secret sauce. As long as you can do that, it can stay secreted, and that might be valuable intellectual property for whatever business that's involved with that secret. there could be a patentable item that's trade secreted. For instance, if there's a process that you would normally patent, but you can keep it secret, you might be interested in keeping it as a trade secret rather than a patent, because a patent has a fixed term, and you have to disclose to the patent office what the invention is to be able to get a patent.
Now, do you suppose the NSA knows what the secret formula to Coca-Cola is?
I'm thinking that the NSA knows everything. It's funny. I think they know everything, but they know so much that they don't know what they know.
Yeah, I understand what you're talking about. Yep.
I don't know. You tell me. What do you?
How
think?
poetic, yeah.
Does the NSA know? I mean, I think they have so much access to so much great technology. They just think they got to do it all.
Well, you see, in this case, what we're talking about, even if the NSA knows the secret formula to Coca-Cola, they can't do anything with it because Coca-Cola has it protected as a trade secret, right?
That's right. That's right. Yeah, I don't know what they would do with it. And trade secret, it's kind of interesting. Trade secret is federalized. There's a Federal Trade Secret Act that was just enacted not that long ago, 15 years ago or so. And it's one of the only areas that you can actually go to jail under for violate an IP statute, an intellectual property statute, for violating that statute. In fact, what happened is, I don't know if you remember, it's longer than I probably think, but it seemed like it was about 10 or 15 years. It was right after the statute was passed, within a couple of years, that a secretary at Coke came across the secret and thought it would be a good idea to mail that secret to Pepsi. And as soon as Pepsi got it, they knew what they had, and did the absolute right thing, and secreted it themselves, notified Coke. And that secretary, he or she, I think it was a she, went to jail for a good long time. I think the time for transporting a trade secret over state lines for the purpose of selling it is 15 years. I mean, it's a pretty serious statute.
Yeah, no kidding.
And it's the only realm of intellectual property that you can actually go to jail for.
Now, speaking of intellectual property, you hear that a lot these days. Sometimes people even refer to a PowerPoint presentation that they put together as intellectual property. But I think intellectual property is also used in the context of computer programming, written code, apps, that kind of stuff. There's a lot of that going around these days. Is that right?
It certainly is, and you're absolutely right. A PowerPoint presentation is intellectual property. Anything that it's copyrightable. Anything that you put in a fixed, tangible form can be copyrighted. So if you make a PowerPoint presentation, since it's in a fixed, tangible form, even if you don't print it out, it's in a fixed, tangible form on your computer, that's copyrightable, and you could register that copyright. And if someone takes it, that would be copyright infringement.
So is all intellectual property considered some type of copyright, or can intellectual property be a patent or a trademark?
It's all the above. Intellectual property, in its broadest terms, are things that are copyrightable, things that are patentable, things that are trademarkable, registered by trademark, and also trade secrets. And there's other forms of intellectual property too that don't fall in those categories. This talk. Okay, for instance, you're recording the talk. Mm-hmm. That recording is in a fixed, tangible form. You own a copyright in that talk, in this discussion. Now, if I would just be talking to you over Skype, I'm transmitting information. You're transmitting information. That's intellectual property. But if it's not being recorded, there's no way to protect it.
Okay. Now, you do know this is being recorded, right?
Sure. Yeah, I do. Yeah.
Just making sure.
Yeah, that's perfectly okay with me.
And I'm okay with you. You're going to give me the copyright to this, right?
Yeah, you have the copyright. Actually, that's a good question. Who owns the copyright right off? You're the one doing the recording, and
Uh-huh.
so therefore you would likely be deemed the author, even though I'm doing most of the speaking. You would be, I think, I'd have to think about it a little bit. It's a gray area, but you would be the author of the audio recording, and therefore you would own the copyright. And
Yeah, that's interesting to bring that up, especially with the new wave of podcasting that's going on across the country or the world, for that matter, in iTunes and Stitcher Radio and everything else.
Yeah, absolutely, and it's a big deal because as soon as that material is put in a fixed tangible form, as soon as anything is put in a fixed tangible form, either by this podcast or this audio recording, the PowerPoint presentation we talked about, if you write notes, as soon as you put things in a fixed tangible form, you automatically own a copyright in that material. Now, to enforce that copyright, you have to register it with the Copyright Office, which is part of the Library of Congress. You have to register it to be able to enforce it. But you own a copyright in everything that you author that gets put in a fixed tangible form.
So as an example, with what we're talking about right now, would I have to register every single podcast, or do I just have to register Veteran on the Move and all the podcasts that exist within that?
There's a way to register serials, and you could probably, if you do this on a regular and routine basis, you could register the serials. But at some point, you have to submit to the Copyright Office all of the audio files. You have to give them a copy of the thing that you're registering. So think of magazines. I mean, this is why they created the idea of a serial copyright. Time magazine comes out 50 times a year or 52 times a year. Do they have to file registration every time? No. I believe it's been a while since I looked, but I think a serial you have to register once a quarter. And you get a copyright on all those issues once a quarter. And it would be exactly the same thing for a podcast that was done on a regular basis. So, but the point is, you have to register it to be able to enforce it. You don't have to register it before an infringing event, but it's highly recommended because you can get what's called statutory damages. If you create something, fixed tangible form, it gets infringed upon, someone copies you, and then you sue, and then you register, and then you sue, you can only get actual damages. You have to prove how you were damaged in that copying. But if you create it, register it, then someone copies you, you can just ask for statutory damages, which are written right in the statute. You can get up to $150,000 per instance, I believe, for copying if you register it before someone infringes. So there's a good rationale for infringing. I'm sorry, for registering. And registering is easy and cheap. It's $35, and if you can fill out a 1040 EZ, you can do a copyright form.
Oh, really? Yeah. The way you were talking there, I was thinking that this is very complicated and very expensive to do.
One page, $35. I forget what it is for a serial, but it's in that order of magnitude. It's pretty easy to do. First time's the hardest. Second time's piece of cake.
Great.
You just got to fill it. Read the form, read the instructions. You might have to give the Copyright Office a call or talk to someone about filling it out, but it is not hard. So
okay, so talking about cost of registering, whether it's under the context of patents, copyrights, and trademarks overall, here's what I would call the patent dilemma or the entrepreneurial dilemma. Especially when you're starting out, you don't want somebody to steal your idea, but you also can't afford to pay $3,000 for every harebrained idea that you come up with before you even know it's going to work out or start producing something for you. So what would you recommend in that case?
Well, I tend to try to be polite but firm when I talk to entrepreneurs about IP costs, because typically they vastly underestimate, like you said, what IP costs to secure and to enforce. But that being said, if they do underestimate that, then they vastly underestimate the cost of everything else it takes to start up a business. So when folks get into the entrepreneurship business, or try to start up a new business, they really need to go into it with eyes wide open, and they need to do their homework. And patent costs are high. I usually tell clients from start to finish it's going to cost them $6,000 to $8,000 to patent something. And they usually gasp and grab their chests when they hear that. But it's going to be 10 times that for all the marketing and all the manufacturing that they have to do, and everything else. So they really need to do their homework and figure out how they're going to pay for it. And can they pull themselves up by their bootstraps and get grants and get help from the state? Oklahoma is really good as far as providing a lot of opportunities for help. There's not a magic trough of money out there you can dip your nose into, but there's a lot of people there to help you, and it takes hard work to get that grant money. But that's one way to go, is to try to get some grant money to get the business up and running. And people ask me, in fact, I just had this conversation with the Chamber of Commerce the other day, and they said, "Well, can you give small businesses a break?" And I'm really sympathetic to that, but at the same time, patents and copyrights, they're luxury goods. No one needs a patent or copyright to survive. I'm more than willing to give up my time, and I do it all the time, to help people with things like family matters and divorces and things like that are critical. But as far as cutting people a break for my time for patents and trademarks, that's like saying, cut me a break so I can buy a Rolex. I'm not interested in doing that, and that might seem kind of harsh. And I spend a lot of time with small inventors, and one of the things that most attorneys will do is give up their first hour for free, and you should ask them
Sure.
to do that, and you can get a lot of information in an hour. Especially if you go to 2 or 3 attorneys and try to get different information.
Uh-huh.
There's a lot of people out there to help you. My rates I think are pretty reasonable, and it's the sort of thing that you gotta decide and plan for, because it's just part of the game.
Oh, absolutely. And I have used for and paid your services several times already, and of course you've also given me quite a bit of free advice on the phone or via email along with that too. So I appreciate it. It's been some great lessons, and helped me dramatically so far. And I plan on staying in touch with you and using you in the future. Along those lines, do you have to be a student at Oklahoma State in order to use your patent attorney services?
Oh no, I'm a private attorney in Stillwater. I have a lot of connections with the university, but no, I see clients. In fact, I'd say 95% of my clients are off campus. So I have a couple on campus, but for the most part, they're all off campus. And I've enjoyed working with you. And I wasn't singling you out when it came to for free time. It just, some people are different, have some wild expectations about what attorneys can do and what they can't do. And this area of the law it's a luxury good. I see desperate people every day that in other facets of life that need help, and I sympathize with them. I sympathize with inventors too. Obviously, I like to see inventors succeed, but it's a different area of the law. So.
Now, I've heard a couple other people mention that. I think Steve Jobs had talked about this, and I know Guy Kawasaki who worked for Apple for many years also said the same thing. If you keep all your ideas to yourself, you'll never get anywhere with them. So don't be scared about sharing your ideas with others, especially when you're trying to get help to get started, because ideas are really a dime a dozen. And it's not so much the importance of the idea. What's really important in the context of entrepreneurship is taking action on those ideas. Now, as a patent attorney, I don't know if you have the same opinion about sharing your ideas or running your ideas past people. And I think I even had this discussion with you myself on some of my ideas. And one of the things you mentioned was a non-disclosure agreement. And I've mentioned non-disclosure agreements with a few people here and there, and was even told by one entrepreneur guy that non-disclosure agreements are considered JV these days, or a lot of people won't even sign them because not that they want to steal your idea, but they don't want to be accused of your ideas somewhat resembling something they may do in the future anyways, and then having you come after them.
Yep.
And, yeah.
There's certainly different classes of people that non-disclosure agreements work for and don't work for. Typically, if you're in an inferior market position and you ask someone in a superior market position to sign an NDA, they'd be crazy to say yes. Okay, so let's just say you came up with a new. We were talking about the Nike swoosh. Let's say you came up with a new way of manufacturing a shoe. And it was just in your garage, and you came up with this new manufacturing technique, and you said, "Hey, I'm going to get a Nike, and I'm going to get them to sign an NDA so I can tell them my new process." You're going to get laughed. They're not even going to pick up the phone. They'll laugh you out of the room because, first of all, there's a significant liability on their part if they sign it. An NDA is a contract, and they don't want to enter into a contractual relationship with someone who might come back and sue them under contract, because suing under contract is fairly serious business. There's a lot of advantages to suing under contract, and they don't want to be in a disadvantaged position in that case. And they're working on a lot of things too, and they might be working on something real similar, and they don't want to be accused later on of coming up with the same thing. So it doesn't work, an NDA, if you try to approach someone with a superior market position. You really do need a patent application on file to show them, because then it's absolutely clear what it is that you have. But where an NDA does make sense is if you're looking for, say, manufacturers, then you're in a superior marketing position, because you're in a position to dictate to a manufacturer whether you will or will not use them to manufacture your product, or a marketing company, or a supplier of some sort. It's very reasonable to ask for an NDA. If there's parties of equal market share, then it's a coin toss whether an NDA works. So they have their place, but they also have their limits. The best thing to do is, if you have an idea, is either to decide you want to pursue it, and at that point file a provisional patent application as quickly and as effectively as you can to get protection, and then use that to leverage either people in superior market position or not so superior. But I do both. I mean, if I was going to a manufacturer to manufacture a product, I'd get it on patent if you were serious about the manufacturing, and also get them to sign a non-disclosure agreement. The folks who want to get your money, they'll sign an NDA. The folks that are going to give you money, not so much. They're not going to want to sign an NDA. So,
all right, that definitely clears that up. I believe it was one of the professors at Oklahoma State, unless it was you, had said when you're in this predicament and you really don't have the money to move forward with some type of patent, copyright, or trademark, one of the things you could do is document what you're doing and everybody you're talking to in the form of an inventor's notebook. Have you ever seen anybody use one of those, or would you recommend doing that, or does it really do you much good?
It does you a tremendous amount of good. I don't know if you can see this one. I do work for that small defense contractor here.
Uh-huh.
Do engineering work, and I keep an inventor's notebook all the time. And what you want is the type that have sewn binding. Okay, so not a 3-ring binder.
That's so you can't plug things in after the fact.
Exactly. I don't know.
Yeah, just like a regular logbook.
It has the pages numbered in the upper left-hand corner, so it's clear that you haven't added or deleted pages. And keeping an inventor's notebook like this, you get these at Staples for they used to be $5. Now they've really gone up in the last couple of years. Now they're like 15. But yeah, keeping an inventor's notebook is not only recommended, it is essential if you're doing inventive work, because even under the new patent law system, it's probably even more important under the new patent law system, because the one thing you can't do is derive an invention from somebody else. Another way to say that, derivation is a fancy word for stealing. So, if you're working with someone in another company and you're showing them your work and they rip you off and try to get a patent for it, if you have it written in your notebook that you invented it before you met with them or showed them, that's gonna invalidate any patent attempts that they might have. So derivation is key now. It used to be first to invent, but now it's derivation. And yes, an inventor's notebook is essential, a very important tool.
So in other words, that could kind of be the poor man's patent or copyright protection.
Yeah, and I wouldn't diminish its value by saying it's a poor man's patent. It's just an essential tool for all inventors.
Have you actually seen an inventor's notebook have that much influence or power in a lawsuit or in court?
Absolutely. There's cases all over the place about the use of an inventor's notebook. In fact, the discussion that we're all having now, attorneys and practitioners alike, is should we have electronic notebooks? Well, judges know what these are. Right.
Right.
They can get their mind wrapped around these. It's harder for a judge to get their mind wrapped around an electronic notebook that can be changed, altered. There's systems out there that archive and timestamp and do all that stuff. But quite frankly, I think judges don't trust them. And I think inventors' notebooks. I'm not a Luddite. I'm a first adopter in just about everything except record keeping for inventions. This is by far the cheapest, easiest way to go, and you can archive them. I mean, if you're worried about using them, scan them and keep the scanned images in a file. So,
well, actually, from that knowledge that was given to me, I actually have an inventor's notebook, and I've got a couple of my ideas written down in there, and people I've talked to about it. You being one of them, by the way. Still haven't made any more progress on a couple of those ideas that I have talked to you about, but they're in there, and the idea is still there. It's just a matter of me finding the time to take some action on it.
Sure. Well, and it does take time. I mean, it's the sort of thing when you're doing stuff every day, it's a lot easier to keep a lab notebook, because this goes. Ouch! Just pinched a nerve. I just did it again. When I'm over doing technical work for this company, this is just with me all the time, and so it's just a habit, a routine that I'm always writing in it, and it's a good way to do that. So,
okay, well, you've given us some valuable information, stuff that I've talked with you about before, and that's why I wanted to have you on here and share your knowledge and information with everybody else. By the way, you're not charging me for this, are you?
No.
No. All right, just kidding. But anyways, first of all, I wanted to give you a chance to put in a plug or a shout out to yourself for how somebody, if they want interested in your services, might be able to contact you?
Oh, sure. Thank you. I appreciate that. Yeah, my name's Marty High. I probably should have said that at the beginning of the podcast. My name's Marty High, and I'm probably easiest to reach at my email address, which is just Marty, Marty, at martyhigh.com, all one word. So Marty at martyhigh.com. And I'm a private practice attorney in Stillwater, Oklahoma. You can also reach me at 405-747-7113. I've been in private practice since prosecuting patents since about the year 2000. First as an agent, and then I went to law school late in life, and been practicing as an attorney for almost 10 years now as a patent attorney. 14 years as an agent, 10 years as an attorney. I do all sorts of legal work. I like to do patent prosecution. That's kind of my favorite area of work. But I also do incorporations in Oklahoma. So if anyone calls me outside of Oklahoma, for instance, if you're interested in getting represented before the PTO, I can typically do that. But if there's a state law question, then I have to defer that to an attorney who's licensed in that particular state. So I actually do get a lot of work from out-of-state folks, because living in Oklahoma and practicing in Oklahoma, I can keep my overhead costs pretty low. So that's my pitch. So glad to talk to you if you'd like to give me a call. Marty at martyhigh.com, 405-747-7113.
All right, that's great. And my last parting words would be, if you're out there and you've got some kind of an idea and you got a patent, trademark, or copyright question, don't hesitate to send Marty an email and have a quick discussion with him, and he will tell you right away whether it's something worth pursuing, or save your money and don't waste your time at it, and come up with alternatives. And it'll be a very informative experience at the very least. And his prices are much more reasonable than any other patent attorney I've run across. So highly recommended. No pun intended there.
I appreciate that.
Well, all right, sir. Thank you for being here today and sharing your wisdom with us. It's a wealth of knowledge, and certainly know that our listeners will get a lot out of it.
Well, I appreciate it, Joe. Thanks a lot, and take care.
All right, Marty. We'll talk to you later. Well, if there's one thing you should take away from this discussion, is that you need a guy like Dr. Marty High on your team. As an entrepreneur, you don't want to get caught up and bogged down in the weeds. Do not want to try to figure out patent law on your own. You've got more important things to do. And as you can see from talking with Marty, there's a lot out there when it comes to patents, trademarks, and copyrights. And a guy like that is worth his weight in gold when you get to that point in your entrepreneurial pursuits. So that's it for today, folks. Thanks again for joining us. Thank you for listening to Veteran on the Move, your pathfinder to freedom. If you like the show, leave us a review on iTunes. Reviews are always greatly appreciated. So until next time, this veteran is Oscar Mike.